Hey guys and gals, this is the Bar Exam and Chill podcast. I'm your host TJ, and today we have a California July 2016 essay. So typically if I was doing the bar exam, I would go down and look at the questions. Let's take a look and see what we're in for today. Number 1, did City High's termination of Paige without a hearing violate the procedural due process guarantee of the 14th Amendment to the United States Constitution? Discuss. Number 2, how should the court rule on the state and the attorney general's motion? Discuss. So immediately you should garner that we're in a ConLaw question, and we're going to be paying special attention to these actors: City High's termination of Paige, and then question 2, it has state and attorney general's motion. So as you go through the hypo, you want to kind of take a gander at the positions of City High, state, attorney general, and Paige, because that's what we're going to be analyzing. So let's go right into it. This is question 4 from California, July 2016. State X has a valid contract with public school teachers providing a fixed salary schedule. State X recently passed legislation to address its failing public schools. Now, when a school falls below established standards, each teacher at that school has 10% of his or her salary withheld each pay period for a maximum of 2 years. The withholding ends, and the money is returned with interest upon the completion of a 10-hour certification program or termination of employment. City High is a public school in State X, where salary withholding has begun. Bob has been a teacher at City High for the past 3 years. Paige is a highly regarded probationary teacher at City High. A probationary teacher may be terminated for any reason upon written notice within the first year of employment. Bob and Paige have been outspoken opponents of the State X law and its application to City High, appearing at various community and school board meetings throughout the school year. Shortly before the end of Paige's first year of employment, City High served her with written notice terminating employment and refunded the money withheld with interest. Bob and Paige have sued State X, the Attorney General of State X, and City High in federal court, seeking damages and injunctive relief. State X and the Attorney General have moved to dismiss the suit based on standing and the 11th Amendment. So we've got, again, these 2 questions here. We're analyzing the first question: did City High's termination of Paige without a hearing violate the procedural due process guarantee of the 14th Amendment? So our issue is, City High has fired Paige, and they possibly didn't give the required notice and hearing that is typically required under the 14th Amendment. That's going to be our analysis. So the issue is, did City High deprive Paige of a protected property or liberty interest without due process when it terminated her employment without a hearing? All right, and our rule is that the Due Process Clause of the 14th Amendment prohibits state and local governments from depriving a person of life, liberty, or property without due process of law. To establish a procedural due process violation, a plaintiff has to demonstrate 3 things. 1, state action. The action was committed by a state or local government entity. That's always the first prong in these constitutional analyses. You're always asking yourself, is it the state that's acting? 2, deprivation of a protected interest. The plaintiff has to be deprived of a recognized property or liberty interest. And 3, lack of adequate process. So the state has to fail to provide adequate procedural safeguards, typically notice and an opportunity to be heard, a hearing, prior to the deprivation. All right, so people have a property interest in employment, right? If you're working for the government in a state or local entity, then you have a property interest in remaining employed. So typically, if they want to deprive you of that interest, then you have to have those procedural safeguards under the 14th Amendment of notice and a hearing. So if they just do it without that, then that could technically be construed as a violation of due process under the 14th Amendment. So we've got our rule, we've got our breakdown there: 1, state action; 2, deprivation of protected interest; 3, lack of adequate process. We're kind of looking at employment, right? Because Paige is being terminated. And it is asking specifically about Paige here. The hypo did mention this other guy, Bob, who we will want to keep in mind. But let's get into So property interest in employment, right? To have a property interest in continued public employment, an employee must have a legitimate claim of entitlement to it, not merely a unilateral expectation. So this entitlement is typically created by state statute, local ordinance, or express employment contract, which might have, for example, a for-cause termination clause, or established institutional policy like tenure. So if a professor is tenured, then they would have a property interest in employment, and it would have to be a public university, right? Not a private university. So at-will or probationary employees who can be fired for any reason lack a protected property interest in their employment. That's going to be a very important distinction here because you have two different employees. You've got Bob, who it says, quote, it has been a teacher at City High for the past 3 years. And you've got Paige, who is, quote, a highly regarded probationary teacher at City High. And then it gives us here in the facts, a probationary teacher may be terminated for any reason upon written notice within the first year of employment. All right, so we've got a property interest. We also want to analyze under the liberty interest. So you got a property interest and a liberty interest. Well, what's a liberty interest? A liberty interest is implicated if a government employer terminates an employee while making public stigmatizing charges that severely damage the employee's reputation and foreclose other employment opportunities. This is also called the stigma plus test. So if they fire you and they really, talk shit about you and it really ruins your ability to get future employment, that could be construed as the government denying you this liberty interest in employment because they're taking away your future right to seek opportunity. So let's apply these rules here. We've kind of laid out the rules. Let's apply them to the facts. We've kind of talked about the facts already, but do we have prong one, do we have a state action? Well, City High is a public school, so it's going to qualify as a government actor, and the state action requirements met here. So we move on, right? Prong number two, deprivation of a protected interest. And as we kind of laid out, you've got these two sort of interests, property interest and a liberty interest. We kind of discussed those. So let's analyze on the facts. Has there been a deprivation of a protected interest? Let's start with the property interest. So Paige has to show that she had a legitimate claim of entitlement to her job. But as we kind of noted here, the facts state that Paige is a probationary teacher and that under the rules, a probationary teacher may be terminated for any reason upon written notice within the first year of employment. So because City High possesses the contractual and statutory right to fire her for any reason during this first year, Paige had a mere unilateral expectation of continued employment, not a legal entitlement. Consequently, our analysis is going to be that she lacks a constitutionally protected property interest. So it's important to distinguish here between, again, Bob and Paige. Bob, he's been there for 3 years, so he's going to have an actual property interest in his employment, whereas Paige has this, under the statute, they can fire you basically within the first year as long as they give you written notice. So here under the property interest, we're going to find that Paige probably just has a unilateral expectation of employment. And so it's not going to be, a deprivation of her property interest because she doesn't really have a legitimate property interest to protect here. So bam, that's going to be our prong two for property interest. Now we're going to want to analyze, was there a deprivation of a liberty interest? Okay, so a liberty interest is implicated, again, if a government employer terminates an employee while making public stigmatizing charges that severely damage the employee's reputation. So we kind of look at the facts here. It doesn't really seem like there are facts indicating that City High made any public defamatory or stigmatizing accusations against Paige when terminating her. She was simply served with written notice of termination. That's what we have in our facts, right? Therefore, no liberty interest was deprived. So the process due here. Because Paige was not deprived of a protected property or liberty interest, the constitutional requirement for procedural due process does not trigger. City High was not required to provide her with a hearing before or after terminating her. That's going to be into our conclusion, right? Conclusion is going to be, right, and we got to kind of look at our, so on that 3, the lack of adequate process, she just didn't have a protected interest here. So there, the process that they followed under the statute, just saying they give her written notice, that's not going to be a lack of adequate process. That is going to be a sufficient process here under Paige's facts. Again, the question is, did City High's termination of Paige without a hearing violate the procedural due process guarantee of the 14th Amendment? So our conclusion is going to be no. City High did not violate Paige's procedural due process rights because her status as a probationary at-will employee meant she lacked a protected property or liberty interest requiring a hearing. Awesome. So we've analyzed the shit out of that one, and we're looking good. As long as you just got to remember, right, for your rule here, due process clause violation, a due process clause of the 14th Amendment prohibits state and local governments from depriving a person of life, liberty, or property without due process of law. So we've got these three prongs: state action, deprivation of protected interest, lack of adequate process, and we're coming down on the side of no. There was no constitutional violation here. Paige was fired, and they had every right to fire her. So let's look at question 2 here. How should the court rule on the state and the Attorney General's motion to dismiss? So the state and the Attorney General have moved to dismiss based on 2 distinct grounds that we are given here: Article 3 standing and the 11th Amendment. So we're going to lay out our rules, one after another. We've got the standing requirements, and then we're going to discuss the 11th Amendment. So let's talk about our Article 3 standing. Our issue here is, do Bob and Paige, and this one we're analyzing both, right? So let's see. We just want to see the question: how should the court rule on the state attorney motion to dismiss? Is it both of them? Let's look here at the facts. It says that here at the end, Bob and Paige have sued State X, the Attorney General of State X, and City High in federal court seeking damages and injunctive relief. State X and the Attorney General have moved to dismiss the suit based on standing and the 11th Amendment. So it's Bob and Paige. They're both suing. And so we're going to analyze both of them. And we are going to start with standing. So we actually talked about this in a previous episode, so this is a great review. We've got, again, 3 rule elements. We've got 3 rule elements for our standing analysis that we have to have memorized. These are, you got to have these down cold for the bar exam. They're pretty easy, though. I feel like they really emphasize this in law school. So for Article 3 standing of the U.S. Constitution, the U.S. Constitution limits the jurisdiction of federal courts to actual cases and controversies. That's how you might want to introduce this standing analysis, right? You just kind of start off with, well, Article 3 of the U.S. Constitution limits jurisdiction to cases and controversies. So if they're going to be establishing that it's a case or controversy, plaintiffs got to prove 3 elements. Number 1, injury in fact, right? A concrete, particularized harm that is actual or imminent. It's not hypothetical. So I remember in law school, they talk about that case where the guy got beat up by, I think it was LA County. It was the police officer, right? And they basically said, well, you don't have a concrete particularized harm here because, the police probably aren't going to beat you up in the future or whatever. So there's some pretty crazy rulings that they can come down on for standing. I know that the other one that kind of shocked me was the government spying on all of those activists, journalists. I think Chris Hedges brought a lawsuit against the government, and they also found, well, you can't prove that you specifically were being spied on, so you don't have an injury to bring the lawsuit. So first prong here, injury in fact. You got to have a concrete, particularized harm that is actual or imminent, not hypothetical. Injury in fact. Number 2, causation. The injury must be fairly traceable to the defendant's challenged conduct. So you've got causation, traceable to the defendant. There's your standard. And 3, redressability. The court has to be able to do some shit about it. So redressability is, it must be likely that a favorable court decision will remedy the injury. So you've got your 3 prongs: injury in fact, causation, redressability. You would probably just want to throw up in bold like a little header, and we're going to analyze for Bob and Paige each of these requirements here. And we're going to find, do they have standing here? So standing for injunctive relief, by the way. So to seek prospective injunctive relief, a plaintiff must demonstrate a real and immediate threat of future injury. That's where that police case that I was talking about, that's where they failed for standing, right? Because they were seeking injunctive relief. Basically, in that lawsuit, they were trying to stop the police department from beating people up. And the court was like saying, under this prong for standing for injunctive relief, you have this standard, which is, you have to seek prospective injunctive relief. To seek prospective injunctive relief, you've got to demonstrate a real and immediate threat of future injury. So that's where it failed under that case. That's how I remember it, just because I was like so shocked by that holding. It was crazy to me. So that standard that's how I keep that in mind for the injunctive relief standing. The requirements for injunctive relief under the standing analysis. Okay. So past exposure to illegal conduct does not in itself show a present case or controversy regarding injunctive relief. How does that make any fucking sense at all? But that's the law. So you've got to know that if you're seeking injunctive relief, you've got to show this future injury, right? Because I guess it kind of makes sense in that, if you're going to have standing for a future injury, the court's going to want to be able to do something about it. I guess they're saying, well, we can't really do anything about the police beating you up in the past. We can't go back in time and make the police not beat the shit out of you. So you've got to show for this injunctive relief that we're going to be able to do something about a future injury. And if you can't prove that you're, liable to be injured in the future, then you're going to fail for standing under this injury in fact requirement for injunctive relief. Okay, and we're going to talk a little bit about mootness here. So we've got this mootness doctrine under, in this realm of standing. Ripeness and mootness are two things you're going to want to know. Well, what is mootness? If a plaintiff's injury is resolved or remedied before the court issues a decision, the case becomes moot and must be dismissed unless an exception applies. So, all right, we've gone through the rules here. Those are going to be our applicable rules on the facts that we've been given. We're going to analyze under this 1, injury in fact, 2, causation, 3, redressability standard for Paige and Bob. Let's start with Bob, because we already kind of talked about Paige a little bit. So let's apply it to Bob. Bob standing. Bob is a current teacher at City High where salary withholding has already begun. Okay, so injury, he is having 10% of his salary withheld each pay period, which, that is a concrete and actual financial injury, right? He's losing money. So that seems to be a concrete injury. It's going to happen in the future, right? If we're seeking injunctive relief, or if they continue doing this, they're going to continue withholding his pay in the future. So it looks like we've got an actual injury here. So let's talk about causation. Is this traceable to the acts of the defendant, right? Well, it's the state that is withholding the salary. So the withholding is directly caused by the enforcement of state X's legislation. Therefore, traceable to the acts of the defendant here? Yes, you've got causation. And then we go into redressability. Can the court do anything about this shit? Well, a damages award would return his money. Okay, so that's pretty nice. And an injunction against the state law would stop future withholdings. So can the court do anything about it? Yes, they can. So here we're going to say, look, we went through all the 3 factors. Bob looks like he has standing. He's got an injury. The state is the one causing it, and the court can do something about it. So Bob, standing, conclusion, yes, Bob has standing, right? That's our application. Then I would go into Paige. So let's talk about Paige. Is she different? Yes, she's a probationary teacher, right? So we're going to have sort of a different analysis here. Well, Paige was terminated, and her withheld money was refunded with interest. Now, it says that up in the facts, that Paige was terminated, and her withheld money was refunded with interest, by the way. That's kind of interesting. This would definitely never happen in real life, but they give us that fact, and it seems like it's really important. So let's see how this kind of factors into our standing analysis. Injury. Okay, well, was Paige injured? Because City High refunded her withheld money with interest upon termination, any financial injury caused by the state's withholding law has been completely remedied. Her claim for damages are going to be moot then. It's going to be moot because they gave her the withheld money. And as we kind of talked about, there's no procedural due process violation in them terminating her. There's no issue there. I guess there is an injury in that she was terminated, but they did it lawfully. So we've got these requirements here. Is there an injury? And we're going to go with, because they refunded all her withheld cash and or her withheld income, and with interest, by the way, because that's how you would, in a court, you would argue you're owed it plus interest. So they paid the interest on it. So her claim is going to be moot here. So injunctive relief, Paige is no longer employed by City High. She was already terminated. She faces no threat of imminent future salary withholding, and they refunded it. So therefore, she's going to lack standing to seek an injunction against the enforcement of the state law. And maybe we could talk about causation regarding termination. Well, Paige suffered an injury by being fired, right? It's potentially as retaliation for her outspoken opposition. She was fired by City High, not State X or the Attorney General. Ooh, did you catch that? That is a toughie, huh? So we are analyzing. This is where you got to be very clear about who you're analyzing for, right? And that's kind of why in the questions, when I start with the questions, right? Part of the thing you want to really notice as you look at the questions is who is it asking you about? And you want to keep your people in these hypos like very distinct because everybody has different interests in a lawsuit. So our question here is, how should the court rule on the state and the Attorney General's motion to dismiss? Wow, that is pretty tricky here. So City High fired her, right? And we're analyzing the state and the Attorney General's motion to dismiss here. So while Paige suffered an injury by being fired, she was fired by City High. So there's a motion to dismiss here brought by State X and the Attorney General. An injury regarding her termination is not fairly traceable to the state or the Attorney General. Oh my God, that is a tricky one, folks. Holy cow. I had to think about that one. I don't know if I would have caught that one. But you want to pay really close attention to your actors, by the way, in the hypo. This is a great reminder. Keep all of your people very, very distinct in your head. So she was fired by City High, but the person bringing the motion to dismiss is State X or the Attorney General. So is the damage, is her firing traceable to the state of the Attorney General? No. So she's going to lack standing entirely against them. So mootness and standing here for Paige, she looks like she's not going to have standing. So our conclusion here in final is that Bob, right, the court should deny the motion to dismiss as to Bob for lack of standing because he has standing. The court should grant the motion to dismiss with regard to Paige for lack of standing as against the state and the Attorney General. Man, that's a tricky one. All right, so we've got standing. As long as you lay out the rules there and then you analyze, you're going to get some points. So if you miss that tricky question, don't worry too much. As long as you're putting everything out on the page for the grader to see, you're going to get points even if you miss some tricky stuff like that. So in this question 2 here, we've got standing, and then the other part was 11th Amendment. They've got motion to dismiss on standing and also under the 11th Amendment. They've got 2 distinct grounds. So we're going to analyze under the 11th Amendment. So what's going on with the 11th Amendment? Our issue here is going to be, does the 11th Amendment bar Bob's claims for damages and injunctive relief against State X and the Attorney General in federal court? Again, we want to have those players very distinct in our mind. So our rule here is the 11th Amendment prohibits private citizens from suing their own state or a foreign state in federal court for damages or equitable relief. The exceptions to this immunity exist only if, so here's your kind of factors, your rule elements here. Exceptions to this immunity exist only if 1, the state explicitly consents to the suit. So there's a waiver. 2, Congress clearly abrogates the immunity pursuant to its enforcement powers under Section 5 of the 14th Amendment. Nice. So we've got this case, Ex parte Young. It's sort of famous in law school, I think. So under the legal fiction established in Ex parte Young, the 11th Amendment does not bar suits against a state official sued in their official capacity if the plaintiff seeks prospective, injunctive, or declaratory relief to halt an ongoing violation of federal law. However, this exception does not allow for suits seeking retroactive financial damages paid out of the state treasury. So there's our Ex parte Young analysis here. Pretty tricky rules in this one. Let's try and apply this 11th Amendment. We've got our rules stated down. Let's try and apply this to our facts. Well, claims against State X, right? Bob sued State X directly in federal court. There are no facts suggesting that State X has consented to the suit. We don't have that they're waiving. There's no waiving of its sovereign immunity, so we don't have facts suggesting that, and I mean, they're bringing a motion to dismiss here, so we don't have consent. And furthermore, there's no congressional statute acting as an abrogation here. We don't have anything on our facts anyways suggesting that Congress has authorized this suit. Therefore, the 11th Amendment is going to provide absolute immunity to State X, right? I mean, under this ex parte, maybe he could sue like a state official as acting in their official capacity to seek prospective injunctive or declaratory relief to halt an ongoing violation of federal law, right? But they can't seek retroactive financial damages paid out of a state treasury. But that's a little bit irrelevant here because State X is just going to have absolute immunity, and it's not an official that's being sued. But we've got that official analysis when we talk about the Attorney General. So for State X, everything's going to be barred, right? They're out. So let's talk about the claims against the Attorney General here. Bob also sued the Attorney General, a state official. So, Bob is seeking damages, right, because he's having his income withheld, that 10% income withholding. So Bob's request for damages involves recovering the withheld wages. Because paying these damages would require funds directly from State X's treasury, the Ex parte Young exception does not apply. The damages claim against the Attorney General is barred by the 11th Amendment. Nice. That's another little tricky one here. So for damages, if he's seeking his actual withheld wages, then if he's suing the Attorney General, it's going to be coming out of the state treasury. That's not allowed. So he's suing him in his official capacity. We would say that, and then we would go, look, as far as the damages go, where he's seeking his wages, that's no bueno, because that's going to come out of the that's going to come out of the state treasury, so it's going to be barred by the 11th Amendment. Now, as to injunctive relief, you're going to split, right, between the damages and the injunctive relief. Let's talk about injunctive relief. Bob is seeking an injunction to stop the ongoing enforcement of the allegedly unconstitutional salary withholding. Now, right, he's just saying in the future, just tell, he wants the court. Injunctive relief is just the court saying, hey, you can't do that, right? That's whenever you're seeking injunctive relief, you're just seeking the court to either compel behavior or tell somebody to stop doing something. So for injunctive relief, he's just saying in the future, just tell, he wants the court, he's basically asking the court, like, tell them to fuck off. Like, they can't withhold my salary, right? So that's going to be a little bit different standard here. He's not seeking damages that are going to come out of a treasury. So this one will fall squarely within that ex parte Young exception that we've laid out, because it's a request for prospective relief against a state official to prevent an ongoing constitutional violation. Bam. So here, the 11th Amendment is not going to bar his claim for injunctive relief. We've laid out the rule up top and we've applied it here. We've got this sticky issue of splitting between him seeking damages in the form of his lost wages and injunctive relief seeking to stop what he's arguing is a constitutional violation. So, wow, that is really pretty sticky. So what is the court going to do on the motion to dismiss? Well, as to State X, it's granted. The State X is out of the lawsuit, right? They're immune. They've got sovereign immunity. They bow out. As to the Attorney General, the motion will be granted as to Bob's claim for damages, but denied as to Bob's claim for prospective injunctive relief under that ex parte Young exception. Wowza, people. Wowza. That is a tricky bar hypo there. Again, that is, you want to pick up on those little nuances and really keep in mind who are you analyzing and what's going on in your facts. And I don't know if I would have, if I didn't have time to sit down before preparing this, I'm not sure if I would have caught everything there. That is really tricky. So as long as you're getting your rule statements down, those are the most important here, right? You want to go through, okay, so you just want to make sure you have in your mind for sure all of the number 1, 2, 3s. Those are critical for test day. So due process clause of the 14th Amendment, prohibits state and local governments from depriving a person of life, liberty, or property. What do you need there? You need a state action. You need deprivation of a protected interest. Could be liberty, could be property, could be life, right? Or liberty is like, jail and there's a lot of stuff under the liberty analysis, but are you being deprived of something? And then is there a lack of adequate process? So again, the state can deprive you. Unfortunately, the state can deprive you of life, liberty, and property, but they have to give you an adequate process first. Okay. So you've got those three things that you want to keep in your mind, right? Is it a state? Is the state doing something? Are they depriving you of a protected interest? Is there a lack of adequate process? Those are your big ones for the number one. And then, you would try and analyze. Question 2 here, you just go through your rule statement for Article 3 standing. Okay, well, U.S. Constitution limits jurisdiction to cases or controversies. In order to do that, you got injury in fact, causation, redressability. As long as you're pulling them out, 1, 2, 3, and I would probably put a bold header, right, for each one of those and analyze under them. Every time you have like a test where you're going 1, 2, 3, I would bold it. So, those keywords are critical. You want the bar examiners to give you points. So if you pull those like prongs out and you put in bold injury in fact, and then, enter, and then you start analyzing, is there an injury in fact? And you go through it and then, enter bold causation. There's your heading. And then, do your analysis, enter bold redressability. It's more likely that the bar examiner is going to see that you're hitting on those key rule statements and you're analyzing under the proper things. Now, if you come to the right conclusion, I'm sure you get a lot more bonus points in it, and that would be a very strong essay. If you were able to pick out the difference between Bob and Paige, and also that the motion to dismiss is not brought by City Hall, that is very, very, that's some astute reading that you're doing there. So it's we've got a really tough hypo here. Again, you just want to make sure that as you go into the bar exam that you've got these rule statements down so that when you're analyzing, even if you go off track a little bit or you miss some of those really little nitpicky things, you're still going to get points for the headers and, parts of the analysis where you're kind of going under here and analyzing everything properly. So that was a really tricky one. Wow. If you got everything on that one as we went through, congratulations, you're a genius. I am not sure on the bar exam if I would have hit everything on that one. That was very nuanced. It took some thinking. So I do think, though, and you can kind of see this in prior episodes, when you go down into the hypo, below the hypo to read the questions, I think that's a good strategy. That's kind of how I approached it. Go down there, read the questions before you get into the hypo. You're going to see and want to pay attention to who are the people that I need to really focus in on, the actors in the question, because you want to have in your mind very clearly who's acting and doing what, and what are the facts that pertain to them, and then what is the question asking you, right? That gave you a huge heads up. You should be going through your Rolodex of topics and issues in your mind as you start to enter the hypo. The first question's asking you a constitutional inquiry, so you should be going like, look, I'm just cycling in my mind, right? You want to be in constitutional law mode. Just cycling through all those topics in your head and in the outline, like what's going to apply here. And then, as you go through the hypo, you're kind of highlighting facts and trying to keep everything clear in your head. Awesome. We did it. We killed it. If you got everything, congratulations. That was a tough one. And I'll see you guys next time. Happy studying.